One of the most challenging parts of mooting is answering questions from judges. Judges can interrupt you at any time throughout your oral submissions to ask questions. Some of the types of questions you may receive include questions about the limbs or elements of legal tests and standards you rely upon, questions about your authorities, such as about the facts of cases you use, or you may receive questions posed as hypotheticals, testing the limits of your arguments and reasoning.
Today, we're going to discuss our top 5 tips for answering questions. Number 1, make sure you understand what the judge is asking. If you do not understand or do not hear them, you should ask for them to clarify or repeat the question.
Could Your Honour rephrase the question?
Keep in mind that not all questions are probing at the weak aspects of your case. Some questions may be designed to assist you, so make sure you listen carefully to what the judge is asking.
Do not avoid answering the judge's question. Be flexible and ready to depart from your submissions. If they ask you,
"What about the issue of causation?"
and that is the third of your 4 points, do not tell the judge,
Your Honour, that is a great question which I will be addressing later in my submission.
If your judge is curious about something, it's best to answer them right away. Otherwise, they may lose interest or remain confused about the argument you're making. If that's the case, your argument will be much less persuasive and effective.
Number 3, be concise and direct with your answer. The first step in being concise and direct is to think your answer through before speaking. You can take up to a pause of 10 seconds to think about what you want to say before answering the judge's question. You should then, if appropriate, start your answer with a simple "Yes, Your Honour" or "No, Your Honour," and then explain further. An effective answer is a succinct answer. Try not to waffle about any points that are not relevant to the judge's question. Remember, you only have 20 minutes to deliver your submission.
Number 4, be prepared. Before your moot, you should go through your arguments with a critical eye and consider what questions you may receive. For example, you may receive questions about the cases you rely upon or on the weaker elements of your case. It is also a good idea to read the written submissions of your opponents before the moot, as questions are likely to be directed at the key areas of contention in the moot. Some judges may also ask you directly about your opponent's submissions.
Number 5, if you do not know the answer to a question, do not make it up. As a last resort, it is better to say that you are not able to answer that particular question and redirect the judge's attention, or talk about another overarching point that addresses the main issue. For example,
"Counsel, what did the minority decide in that case?"
Unfortunately, I am not able to assist the court in this matter. However, the majority found that excerpts do not have to be short to be considered under the quotation exception, which is relevant to this case, as we have a case where there are reproductions in full.
Now that we've gone through our top tips for answering questions, you should put them into practice and try them out in a moot. For more information on our upcoming moots, please see the Law Soc discussion page, the Law Society website, or the Law Society Facebook discussion forum. We can't wait to see you in a moot.